Hello, everyone. Thank you all for coming to this presentation today, Cannabis and the Workplace, a Changing Legal Landscape. I'm Carrie Cork, a senior staff attorney at the Public Health Law Center. Employment law is a broad and diverse area covering all aspects of the employee-employer relationship. It consists of thousands of federal and state statutes, administrative regulations, and judicial decisions, and includes protective legislation, public benefits such as workers' compensation, and other major areas such as employment discrimination and unemployment compensation. Many of these areas are interrelated and connected to workplace policies. The swiftly evolving landscape of legal, medical, and adult use or recreational marijuana has left many employers, employees, and potential hires uncertain about their legal rights and responsibilities regarding on and off-site use of this drug. As a result, over the last several years, employers in many states have revisited and relaxed their workplace drug use and testing policies. Today, we're going to take a quick look at how many of these rules are changing in response to the use of marijuana in the workplace. As I mentioned, I'm here from the Public Health Law Center, a national nonprofit organization at Mitchell-Hamlin School of Law in St. Paul, Minnesota. Our Center of Attorneys and Public Health Analysts supports public health and commercial tobacco control policy change at the local, state, and national levels. We do this by providing free legal technical assistance to public health advocates and professionals around the U.S. in several ways. We also do presentations and trainings, such as this one. We don't represent clients in court, and we don't lobby. Finally, our organization is committed to the principle that good public health cannot be achieved without addressing health equity. Health equity and the social determinants of health need to be considered in any marijuana regulatory scheme where public health is prioritized. So here's what I'll be covering today. I'll start with an overview of marijuana use in the workplace, then look at federal, state, and local laws that regulate and relate to drug use by employees or job applicants. And then I'll describe the main workplace policies that apply to marijuana use by job applicants and employees, as well as how the laws and policies are changing to accommodate marijuana use. Before we begin, I'd like to set the stage briefly because it keeps shifting. It seems as though every day more states are passing, revisiting, and refining cannabis laws and regulations. So this is just a quick snapshot of the legal landscape in the U.S. as of May 2022. As of today, 19 states have legalized adult use of cannabis, including DC, the Northern Mariana Islands, and Guam. Medical use of cannabis is legal in 37 states, including DC, and 4 of the 5 inhabited U.S. territories. All states, including those that legalize adult use marijuana, prohibit the smoking of marijuana in public areas, such as restaurants, bars, and non-hospitality workplaces. Often, smoke-free laws contain provisions that define tobacco product to include e-cigarettes and similar devices, and define smoking to include the smoking or vaping of marijuana. At the same time, the growing popularity of marijuana use has led at least 7 states and over 60 localities to adopt exemptions from clean indoor air laws that permit the use of marijuana in indoor public settings, such as licensed marijuana dispensaries, cannabis lounges, cafes, clubs, coffee houses, marijuana hospitality establishments, and other social consumption venues. Of course, in addition to patrons, these establishments and venues all have employees, many of whom are likely to be exposed to marijuana smoke on the job. And just as an aside, approximately 428,000 employees work in the marijuana industry to date. Retail and hospitality establishments, however, aren't the only work settings where marijuana use has become an issue recently. The treatment of marijuana in the workplace has become an ongoing concern for employees across the U.S. So let's look at the workforce in general, starting at the federal level. Because marijuana remains an illegal drug under federal law, federal job applicants, employees, and contractors have traditionally been prohibited from using marijuana on and off the job. The 2021 federal workforce contains slightly more than 4 million workers. Federal employees include uniformed military service members, postal workers, legislative and judicial staff, and employees. The federal workforce also includes civilian employees that work in every state, providing services related to healthcare, education, housing, disaster management, securing the nation's borders, coastlines, and waterways, forecasting the weather, protecting and ensuring the nation's food supply, maintaining national parks, and so on. And I'm listing all these occupations as a reminder that federal employees don't just reside in DC, and that the ban on marijuana use applies to a considerable segment of the overall workforce. Also, federal agencies for industries that hold public safety and national security roles also have established drug testing requirements. And agencies such as the U.S. Department of Transportation, Department of Defense, and Nuclear Regulatory Commission must all comply with established drug testing requirements. Okay, so there are several federal laws that prohibit employee use of marijuana. In addition to any federal or state sanctions against use of controlled substances, employers have a general duty to provide a safe workplace under the Occupational Safety and Health Act. Studies have shown that THC can impair abilities necessary for critical thinking and skills such as safe driving and the operation of jobs requiring the use of heavy machinery. Also, all federal agencies, government contractors, and recipients of federal grants must comply with the Federal Drug-Free Workplace Act, which prohibits employees from using controlled substances in the workplace. Some employers could lose federal funding, be suspended or terminated, or be subject to administrative fines if they fail to enforce federal, state, or local policies aimed at achieving a drug-free workplace. This is significant because there are a lot of employers that fall under this category. Finally, several federal statutes protect the civil rights of investigation, discipline, and similar regulatory restrictions related to employee drug use. Lawsuits related to employee drug use are often based on claims involving these federal protections. For example, the Americans with Disabilities Act of 1990 prohibits all U.S. employers with more than 15 employees from discriminating against qualified job applicants and employees because of a physical disability. This category includes recovering alcoholics and drug users who have sought treatment for their addiction. The ADA requires reasonable accommodation of workers with disabilities, some of whom may use medical marijuana for therapeutic purposes. Case law regarding federal disability and discrimination claims by employees who are medical marijuana users continues to evolve. Other major federal laws and regulations that protect employees regarding substance use include the Civil Rights Act of 1964, the Family and Medical Leave Act, and the National Labor Relations Act. Employers considering drug testing policies should be aware of these civil rights protections for employees and consult legal experts about state and federal law and possible intersections. Many state and local jurisdictions, as well as U.S. territories, also have laws that can affect workplace policies regarding employee use of marijuana. In some instances, state legislation legalizing medical or adult use marijuana contains workplace protections. In other instances, employee marijuana use is addressed in local or employer-specific policies. In the past, states generally allowed employers to enforce zero-tolerance drug-free workplace policies by screening job applicants for drugs, doing random employee drug testing, and disciplining or firing employees for marijuana use. Over the last several years, many state and local employers have become more tolerant of employee off-duty use of medical marijuana, and even to a lesser extent, adult use marijuana. For instance, at least 20 states have passed disability and anti-discrimination workplace legislation protecting the rights of employees who use medical marijuana, and a growing number of jurisdictions have adopted a more tolerant stance toward job applicants and employees regarding adult use marijuana. There are two other laws that are often directly implicated in workplace marijuana use. For example, nearly all states require employers to carry workers' compensation insurance, and each state has its own workers' compensation insurance program requirements and penalties. Several states, such as Alabama, Georgia, and New York, offer employers with drug-free workplace programs a discount on their workers' compensation insurance premiums. Other states, such as Michigan, deny workers' compensation benefits to workers whose injuries are determined to be the result of substance use. And some states, such as Wisconsin, reduce workers' compensation indemnity benefits if an employee is injured in the workplace while intoxicated under any controlled substances, including marijuana. As states continue to legalize marijuana and expand the types of medical conditions treatable by medical marijuana, employers will need to stay abreast of ever-changing work comp rules, including coverage of medical marijuana to treat work-related injuries. Also, each state administers its own separate unemployment insurance program, but follows guidelines established by federal law. Some states limit or deny unemployment benefits to employees who are fired because they fail a workplace drug test. Workplace policies regarding drug tests for marijuana are changing, particularly regarding off-duty use in states where the drug is legal. And positive drug state tests for marijuana may not automatically mean that an employee is ineligible for unemployment benefits. And here are just a few fun facts regarding workers' comp and medical marijuana. I think the interesting point is that marijuana in the workplace can be concerning for safety sensitive positions, but it also may safeguard against workers' comp claims in other occupations. And according to a study published in the journal Health Economics, states with medical marijuana programs saw a 7% decrease in workers' comp claims, and this drop may stem from medical marijuana treating many of the same illnesses and symptoms that employees use workers' comp claims to address. Finally, in addition to federal and state employment and civil rights laws and regulations, employers considering workplace policies on marijuana use need to be aware of other state requirements. For instance, in all states but Montana, employment relationships are presumed to be at will. In a nutshell, this means that employers can terminate an employee at any time for any reason except an illegal one, with no adverse legal consequences. And employees may leave a job at any time for any reason with no adverse legal consequences. The intent of this at-will employment doctrine is to prevent wrongful termination and employment lawsuits between employees and employers. 29 states and DC have passed statutory exceptions to the at-will presumption. These statutes protect employees against adverse actions, such as whistleblowing, and certain off-duty activities, such as the use of legal products. For example, 29 states and the District of Columbia have laws in effect elevating smokers to a protected class by preventing employers from discriminating against job applicants and employees for using tobacco products off-duty and away from the job site. The laws are intended to ensure that employers do not consider off-duty legal acts, such as tobacco use, when making employment decisions, such as hiring, firing, or disciplining employers. Some of these laws prohibit employers from acting against employees who engage in off-duty lawful conduct, use, or activities, which one might think would cover the use of marijuana in states where it is legal conduct or legal use or activity. So here are two tables with smoker protection laws in the states that have legalized adult use marijuana. Although 6 of the 11 adult use marijuana states shown in the table have smoker protection laws, they also tend to have laws curtailing the rights of marijuana smokers when it comes to the workplace. And here are the other states. So one more note, under the Affordable Care Act, which eliminates discrimination for many health conditions, employers and insurers are allowed to increase health insurance premiums for smokers and reduce premiums for non-smokers. Even smoker protection laws contain exceptions that allow employers to charge smokers higher insurance premiums. Interestingly, as many employers have taken a less accommodating view toward off-duty tobacco use by employees by increasing insurance premiums on smokers or even refusing to hire applicants who smoke, other employers and jurisdictions are taking a more tolerant approach toward off-duty marijuana use. So let's look now at specific workplace marijuana policies. Many states and U.S. territories require that certain employers develop drug-free workplace policies, and they vary in the way they treat marijuana. About 2/3 of the states now have medical marijuana laws that allow people with serious medical conditions to use marijuana with the doctor's authorization. However, just because marijuana is legal in many states doesn't mean that it's allowed in the employment context. For instance, some states permit employers to take adverse actions against employees, including firing them for using marijuana, regardless of their disabilities. And other states allow employers to accommodate the medical marijuana use of employees based on their status as qualified, registered, or certified medical marijuana users. Although marijuana use is currently not covered by the federal ADA, a growing number of employees have sued employers on state disability discrimination grounds when the employer refuses to accommodate their lawfully authorized use of marijuana for medical purposes. In the past, states have typically allowed employers to enforce zero-tolerance drug-free workplace policies, both on and off-site. And this includes screening job applicants for drugs, doing random employee drug testing, and disciplining or firing employees for marijuana use. Some states limit testing to reasonable suspicion or probable cause situations, while others allow random testing under specific circumstances. Still, other states impose drug testing restrictions on public sector employers, but not private companies. Generally, current employers have greater rights in this area than applicants because employees already hold a job that they stand to lose if the test comes back positive. Applicants stand to lose only an opportunity to get a job. So just a few comments here about drug testing. Marijuana is the most commonly detected drug in workplace drug testing. However, unlike testing for drugs such as cocaine and alcohol, marijuana testing presents unique challenges. For instance, marijuana drug tests can't tell you how much, how frequently, or whether or not someone's impaired. They're just designed to identify the amount of THC a person has consumed. Also, THC can remain in a user's bloodstream or urine long after THC intoxication has ended, which poses problems for employees who use off-duty but test positive in the workplace. Since there's been a lack of consensus on impairment and testing difficulties, it follows that there's been litigation on this issue. There continue to be situations where employees are terminated from positions for testing positive for marijuana, even when they're registered medical marijuana users. And we'll talk in just a minute about litigation. Let's look at pre-employment screening first. Employers with drug-free workplace policies often used to condition job offers upon a job applicant's negative drug test. Because of the difficulty in determining whether impairment occurred off-site or during working hours, it was logistically easier to simply have an outright ban on drug use. Today, given the rise in legalized marijuana and the tightening job market, more and more employers are deciding not to test applicants for marijuana anymore. In fact, several companies recently, including Amazon, the country's second largest private employer, have announced that they will no longer screen applicants for marijuana use. Again, this loosening of drug-free requirements is coming at a time when the post-pandemic labor shortage has resulted in hiring incentives, wage raises, college scholarships, and even gifts to attract job applicants. Also, courts are increasingly finding in favor of job applicants in cases where a positive test for marijuana, typically medical marijuana, results in a candidate's not being offered a job. For example, a federal court in 2018 held that refusing to hire a Connecticut qualified medical marijuana user because she tested positive on a pre-employment drug test violates the state's medical marijuana law, and it granted her summary judgment on the employment discrimination claim. Also, a court in Rhode Island found that an applicant was discriminated against when she was not hired as a paid intern because she admitted she was a registered medical marijuana user who used the drug for migraines. Still, courts remain divided. For instance, the Michigan Court of Appeals recently found for the employer in a case where a fabrics corporation rescinded a conditional offer of employment when a job applicant tested positive on a marijuana test. The court essentially ruled that the legal right to use medical marijuana in Michigan does not override an employer's right to decide whether or not to hire an applicant or to fire an at-will employee. Even so, even as states are continuing to legalize marijuana, employment drug laws are continuing to evolve. On January 1st, 2020, Nevada became the first state to prohibit employers from refusing to hire applicants based on their failure to pass a pre-employment drug screening test. And a New York City law recently took effect, prohibiting employers from testing applicants for marijuana as an employment condition, except for jobs in healthcare, construction, or childcare based on safety concerns. Other states are also considering legislation that would accommodate in different ways employees who use medical marijuana. Now, what about marijuana testing of actual employees? Well, many state laws don't specify symptoms of marijuana impairment that employers may use as a basis for reasonable suspicion or probable cause, although general symptoms of drug impairment or intoxication are typically identified in workplace drug policies. Depending on the individual, some of the most common physiological, psychological, and behavioral marijuana effects described in the scientific literature include disinhibition, relaxation, increased sociability, enhanced appetite, short-term memory impairment, merriment, time distortions, impaired judgment, reduced coordination, and ataxia, which can lead to an increase in risk-taking behavior and impaired driving ability. Employers who suspect that an employee's performance is impaired due to marijuana need to document objective facts that would suggest to a reasonable person that the worker is under the influence in violation of company policy. This leads us directly to another employment area that is changing in response to legalized adult use marijuana, off-duty use. Earlier, I mentioned the Federal Drug-Free Workplace Act that prohibits all employees from using controlled substances. This applies to several types of employers, including teachers, principals, support staff, and other school employees. And that's because federal dollars account for 8 to 10% of most school district operating budgets. So a few years ago, a Texas science teacher who worked for 8 years at her school without any previous misconduct issues left Texas on Christmas vacation and traveled to Colorado, where she consumed some adult use marijuana. I believe she ate an edible. Well, when she returned, she tested positive at her school for marijuana in one of the 3 drug tests she agreed to perform, and school officials moved to suspend her for 2 years. She resigned before they could. The Texas Education Agency took the case to an administrative judge who ultimately sided with the teacher, saying her action was akin to someone gambling at a casino in Nevada and returning to Texas, where gambling is illegal. So this sort of situation is only likely to increase as more jurisdictions legalize adult use marijuana. Despite many enhanced protections for employee marijuana use, Employers continue to terminate employees for testing positive for marijuana, even when they are registered medical marijuana users. In 2015, for example, the Colorado Supreme Court ruled against a registered medical marijuana user who was a quadriplegic and who argued he was wrongfully terminated from his job after testing positive for the drug. Still, recent decisions in federal and state courts suggest that while the first wave of litigation related to marijuana use in the workplace tended to favor employers, the tide may be turning. In Arizona, for example, an employee who was a registered medical marijuana user took a drug test triggered by an on-the-job injury and tested positive for THC. The drug test took place 2 days after the injury, but Walmart still fired the employee, claiming the test result indicated she was under the influence of marijuana when she was injured during her shift. The employees sued Walmart, arguing that the termination violated the Arizona Medical Marijuana Act, and the court agreed, finding she had been wrongly terminated. And in Delaware, a court ruled that a medical marijuana user may sue his former employer after a positive post-accident drug test result from marijuana led to his termination. One more thing. How can employers conduct workplace drug tests in a remote work environment, particularly when both work hours and work premises have been redefined? Recently, several businesses have offered virtual drug testing approaches, such as telehealth collections, which can be done through video conferencing platforms like Zoom or via an app and using oral fluid testing. No state laws currently prohibit telehealth collections, but local statutes could limit how collections are performed or what specimens are used. In sum, federal and state laws and workplace policies regarding marijuana use are changing as the use of both medical and adult use marijuana has become more normalized. Not only are courts finding more for job applicants and employees in issues of marijuana use, but employers are relaxing their workplace policies in this area, particularly with respect to job applicant screening, medical marijuana use by certified users, and off-duty use. Still, employers should be aware that employees who are intoxicated or impaired by marijuana can pose a public safety risk, and no state or federal law protects the right of employees to be stoned on the job. Our organization has a few resources related to cannabis regulation, and we've published a few journal articles on this topic as well, including on this issue. We also have some archived webinars that are all available on our website, publichealthlawcenter.org. So thank you very much for attending this presentation today. And if you do have any questions, please contact me, Carrie Cork, at mitchellhamlin.edu. Please have a good rest of the day. Thank you.